Court does call the case.
Bond terms be more flexible in cases like this?
People versus Kurt Burke.
Are where the court decides if there's enough evidence to send a case to trial. Think of it as a courtroom filter. If the evidence doesn't hold water, the case might never move forward. Should every case get this level of scrutiny first?
Court does call the case. People versus Michael Collison.
Ashley Washington, people. Public defender Sutherland, Collison,
More than what to start calling.
And the police report in this case would like to put no contest.
And I have an advice of rights.
Yes, Your Honor, the police form reports have indicated a cheat to an added count of largely 20,000, an added count of use of methamphetamine, not at possession of methamphetamine in this incident. And a dismissal of the original count of, sorry, I don't have it in front of me.
Count 1
Yes, count.
would be dismissed. He's going to plead no contest to counts 2 and 3. Both 1-year misdemeanors, one larceny, 200 to 1,000, the other use of methamphetamine. Upon a successful plea, count 1 would be dismissed. And people, you're doing this voluntarily and of your own free will? All right. Court has been provided and has reviewed Ann Arbor Police Department reports for their case number 2510459. Actually, 2 reports I reviewed. Counsel, any objections to the court having reviewed those reports?
No, Your Honor. No, Your Honor.
Based upon a review of those reports, the court does find that there's a sufficient factual basis. The court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court?
People are satisfied. Satisfied.
Court will accept the defendant's no contest pleas to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be May 20th, 2025, 9 a.m. before Judge Vallow.
Is it possible to get any later sentencing date? We're working out of these treatment right now, so probably looking into treatment at that time.
You can certainly arrange that with Judge Vallow's office. That is the date that we have. Okay. See, okay. There's a stipulation for release of treatment, which I've signed.
Yes, Your Honor.
And also,
I was asking that be a set aside, Your Honor. I think that was entered when we interpreted the date as, that was maybe in January. We interpreted the date for to be an afternoon date, so we signed on it at 12, and you issued the bench warrant at 9, and it was you were unaware that Mr. Brown was in federal custody at that time, so he didn't appear. He doesn't have any capious history, and we would appreciate that being set aside because he is trying to negotiate a bond on his federal matter, which I don't represent him on that case. But I know that they're trying to do something about it. Mr. McQueel reached out to me yesterday. Unfortunately, I'm in trial. I'm being called in to do, which led to this. So I didn't ask Mr. McQueel. He did send me an email. I just didn't get a chance to get back to him.
all right. I will set aside the bench warrant. I'll reinstate his previous bond in this case.
Thank you.
And then we need to set this for further proceedings. Did you want this set for a PCC?
Please, it's not a, it's not an exam, it's, yes,
Right.
A PCC would be fine.
Whoa, judge just set aside a bench warrant, meaning the defendant won't get penalized for missing court earlier. Turns out he was in federal custody at the time. This moment shows the real-life chaos defendants and their attorneys juggle. Ever seen a courtroom this flexible or forgiving?